Good morning, welcome to Law Power Hour. We've got a little break in the weather today, but be careful out there because it's still icy. And that's one of the reasons I had David Kramer come on today. David, thanks for coming on.
Thanks for having me, Barry.
David, where's your office at?
My office is in Royal Oak, right on Woodward Avenue.
And when I said it's icy out there, that's an important word for people to watch out when they're walking around, is the ice today, correct?
That is correct. You can't be too careful.
What's the duty of a landlord to a tenant with respect to removing ice and snow?
Well, the landlord has a duty to make, as far as the premises goes, safe. And one of the things of being safe is removing ice. If they know there's ice buildup on the walkways or areas where the tenant or the tenant's guests will enter the building or the apartment, that landlord has a duty to make sure that is kept clear and safe.
I think it was last year or the year before, the Michigan Supreme Court came down with a horrible decision as it relates to claims for slipping or falling on ice and snow in Michigan, in which they said that everyone knows it snows in the wintertime and it's icy on the streets, and you can't hold people responsible for those types of injuries.
That's correct, Barry, and it was a horrible decision. And basically, it says that individuals, people on the street, they're on their own. There is essentially no liability, but there are a couple ways that you can establish liability. And the biggest one is notice. It's letting the landlord or who's ever responsible for the premises know that there's a dangerous condition, and if they don't do something, then you do have a basis for a lawsuit.
Okay, let's break this down a little bit. And if you're out there, listeners, please call in because this is an important topic, because this is the time of year where we receive the most calls over slip and fall injuries. Is that true?
That is correct. The winter, the freeze-thaw cycle, that's where we start to see black ice covered up by light snow, things of that nature.
This is not going to be a law school exam, but we're going to back into it together so everybody understands.
Certainly.
We all know that it snows in the wintertime, so we're all on notice of that. Correct?
Our Supreme Court has provided us with that. Yeah, that's true.
So that means that the owners of property are also on notice that it snows in the wintertime.
That's correct.
So do owners of property have a duty to maintain the property so those of us who have to go upon the premises, let's say we're going to a store, we're going to visit someone at their apartment building, do they have a duty to make sure that it's safe for us to enter and exit the property?
They do have a duty, but that duty is, as you said earlier, has been very tempered by this Supreme Court ruling.
But they still have a duty to maintain the property.
Correct. They do have a duty.
And it's our responsibility. For example, let's say we go to the mall, and I'm going to give you a horrible example. It's been snowing out. We all wear our boots into the mall. We're tracking water into the mall. Does the mall have a responsibility to us?
Certainly.
Well, what's the responsibility? Explain to our listeners what the responsibility is.
Well, it's to keep their duty is to maintain their premises and keep it safe from known conditions.
Well, they know that people are going to walk in with boots on, right?
Right. They know it's snowing. They know it's slushy. They know people are tracking it in. So they have basically notice of this condition.
So they've got to have somebody there mopping the floor, keeping it dry, right?
Or yes, mopping it, keeping it dry, warning of the wet or the hazard.
So God forbid you go in the mall, you slip and fall on your way in. What's the first thing you're going to tell our listeners they should do?
Well, the first thing you do is you stay put. You don't leave the scene. You want to call for assistance, but make sure you stay at the scene. You don't want to walk away and make the report. You want to make sure that you're there when any representative from the mall or whomever attends to you.
Would you agree with me that most people who have a slip and fall take the fall, get up, and go about their business only to find out 2 or 3 days later that they're injured?
That is very common, yes, I would certainly agree.
And that creates a big defense, doesn't it, when you try and file a lawsuit?
That is one of the first defenses out of the gate that you'll hear from an insurance company.
And what's the defense?
The, the defense is that you didn't report the condition, so it couldn't have been a hazard, number one, or number two, that you weren't injured enough to seek treatment, so you can't, they'll argue that you're not injured.
Now, let's say you start a lawsuit and you gave an accident report to the mall people while you were there. And you ask them for a copy of the accident report before you start the lawsuit. Are they going to give it to you?
Usually no.
Will you get it after you start the lawsuit?
Yes, you will.
But it's very difficult,
It's
right?
very difficult, yeah, and that's why I chuckled a bit, because it's something that you would believe would be something that would be turned over quickly, but they guard those documents because they tend to hurt their defenses.
Right, so I want you to tell our listeners, and I'm asking you, I asked you off the air, but I want you to tell our listeners everything that they should do if they have a fall, whether it's at the mall or going into a building or going to visit someone at their house. What should they do?
Well, just to reiterate, the first point is stay on the scene. Make sure that you're there, you're able to document and explain exactly where you fell, and hopefully the condition still exists. The whatever you slipped on, be it a damp floor, a slippery finish on the floor, whatever it is, you're there, you can explain it, fill out the report. The second thing would be, if there are any witnesses, if anybody saw you fall, what you want to do is you want to get their names, their addresses, or at least their phone numbers, because you're going to need them to basically explain what they saw and if they were aware of the condition or not. So that's a big thing, is find out who's there, and don't necessarily give that information or allow the mall owners to hold on to that information. Keep that for yourself also. That's your information also. And the other thing is, you have to follow up with your doctors. You really have to make sure, if you're feeling a little bit off from that, or go to the ER, wait for an ambulance, because you don't know that at the time you fall what your injuries are, and it may be something like you said, 2 or 3 days later you feel it. But get checked out right away. Make sure you document with your doctor, whoever treats you, what pains you're having.
One time I had a case where a lady slipped and fell in a fast food facility. No case whatsoever for slipping and falling. But they moved her. They physically moved her. And that's where the claim came in.
Yeah, that's you want to make sure you stay in the area, and you're in charge of your of what they can do to you. So yeah, that's really something.
The point I wanted to make is, don't let people who are not trained examine you or move you. Wait for qualified personnel. That's why you might need an ambulance.
Correct.
And I remember in this case, it was so specific. This lady had a back injury and they moved her. And she said, "Don't move me. I need medical assistance." Remember those words. Don't move me. I need medical assistance. And the last point I wanted to make before we take a break, in gathering evidence, if you've got a phone, what should people do with the phone while they're there?
They should take pictures of the area. They should take pictures of if there are representatives from the malls. For example, get pictures of name tags. That way you'll have witness names, things like that. But you definitely want to photograph, document, and you can call the ambulance yourself if you need to.
Now, let's say you go to the emergency room. After you go to the emergency room, what's the next step?
Well, the next step is you need to follow up. You need to follow up with your primary care doctor, or if you don't have a primary care doctor, go back to the same maybe urgent care facility, but let them know that the reason you're there is because of this injury that happened at the mall, for example. You want to make sure that you let them know that this is still from that injury. You want to just document it and make sure you have a trail of complaints about this pain.
Now, given the set of facts that we described, would you take their case?
If they've documented it, if there's witnesses, if there's documents and there's medical treatment, which relates to real damages, certainly.
Now, let me take you down the road a little bit. There's a lot of renters here in Michigan, and they're renting through property managers, as you told me, with foreign investors, correct?
Correct.
What's the problem in suing a foreign investor?
Well, the biggest problem with these foreign investors, and just to give a little background, is City of Detroit is a prime example. Investors from Europe, Asia have bought large tracts of property, hundreds and hundreds of homes at a time. The biggest issue you run into with a lawsuit against a foreign investor is collecting from that foreign investor. You could spend a lot of time and a lot of money chasing around these foreign investors, and that's kind of how it's set up, is to provide them protection against people who are suing them or trying to collect on them. But that's the most difficult thing, is them being overseas and trying to work through the foreign courts.
But in most of these situations, isn't there what we call a property manager? Somebody managing and maintaining the property for the foreign investor?
Yes, so they'll have a local property management company handle their properties. Most often that'll be a company that's located in Michigan, and they're the ones who are responsible for maintaining the property, for making the repairs. They're sort of the face of that foreign entity that you'll never see. So what we like to do is, or what I like to do is, if you do have an injury at a rental property, is, more times than not, it'll be the property management company that will be the target of the lawsuit, if that's the case.
Okay, let's talk about all the do's and don'ts, and I know there's a whole list of them that you brought with you today, and it's real important for renters. And if you're a renter and you're listening, pay attention to what Mr. Kramer has to say today, because it's really, really important for you to know that there's a lot of moving parts when you rent a piece of property.
Certainly, Barry. There's the one thing is, I represent two folks now who have a claim against a rental company and the foreign investor. But the biggest thing was, when the foreign investor bought the house that they were already living in, they had them fill out a new client questionnaire, and that questionnaire had a long list of questions. Is the plumbing okay? Are the handrails on the porch, are they okay? Does anything need repair? And it was an exhaustive list, and my clients were wise enough to fill this out very carefully, and they noted all of the problems that they were having. And so when, unfortunately, a couple months after this company took over, the gentleman was trying to get his mail from the mailman, and he was holding on to the porch rail, and he lost his balance. The porch rail came out of the porch, and he fell to the ground. They had noted that defective rail months prior. It had gone unrepaired, and they had other claims about the furnace, about the leaking water heater. All these things were documented, and at one point they called the City of Detroit, they call the Property Maintenance Division. They come out, they'll go through the house, note all of the violations, all the things that need to be repaired, and what happened was you had this compiled list of problems that the owners and the management company were aware of, that they failed to repair, and now we have an injury which, in the eyes of the court or a jury, this was certain to happen. Somebody was certainly going to get hurt in this house, and it just so happened it was my client who fell from the porch because of this rail.
Now, there's a different standard with a property manager than there is with the owner of the property, isn't there?
There is, and the problem that you run into is there's sometimes an indemnity clause where you can't, and I don't want to get too technical. The owner of the property is supposed to I guess how would you say it the most eloquently? Be the responsible party to be sued. But yeah, the standard is different, though.
But I mean, you don't have the highest burden that you'd have against the property owner, against the property manager.
Correct. Yeah, yeah, and that's a great point.
And when I use burden, I'll make it simple, responsibility.
Right. Yeah. It's easier course to take, I guess, would be a.
Yeah, the duty of the property manager is to make sure that the property's maintained in habitable condition.
Correct.
And that raises an issue as to whether it's suitable for dwelling and living in. I mean, you gave me a whole grocery list of problems that existed with the property.
Certainly.
So when the property, they receive an occupancy permit for the property, correct?
Right.
They need a renter's license for the property.
Yes.
So people who rent should always check.
To make sure the property is licensed, and it's amazing what these rental agreements will have included in them. And I've seen rental agreements that are 14, 18 pages long, and I mean it's hard for me to understand it as a lawyer, and for people who are renting and just want to keep a roof over their head, it's certainly unfair to have these all of these conditions in place.
Well, you pointed out to me earlier today that there are some problems with rental agreements. For example, if you make a late payment, the charges, if pay by check or however it's done.
Exactly. So these rental these property management companies will have right in their contracts that you sign different fees, and so it's like the classic hidden fee that your rent is, say, $800 a month, but what happens when you go to pay it, if you pay it by mail, there's a $10 charge. If you're 3 days late, there's a $50 charge. If you pay by PayPal, you have to pay a certain amount. So there are all these little charges that you don't realize, but at what happens, your rent is no longer $800 a month, it may be $860 a month, and if you don't pay that $60 that you weren't anticipating back when you signed the lease, you go into arrears, and then you get more charges, and you get caught up in this cycle of, going down and entering into a consent order, a consent judgment to have these arrearages paid, or you'll be evicted. So it's a real tricky and troubling situation.
So here's the situation. Give you the bottom line. You pay a rent deposit when you move in, month and a half rent.
Correct.
The rent deposit doesn't go towards the arrearage, does it?
No, it does not. Oh, wait, I'm sorry. Well, continue.
Okay, it won't go towards the arrearage until you've been evicted.
Correct.
But while you're in arrears, you don't want to get evicted after you move in, obviously. But when you pay by PayPal, or you pay with a check, or you pay by mail, or you're late, you're running $50, $60 a month, over the $800 a month, and you have a problem, because that's cumulative. It goes on for 2 or 3 months, and if you pay on time for the next month and you haven't paid the arrears, you're still in arrears.
You're still behind.
And you're going to get evicted, and it's not right. If you're behind 2 or 3 months, you're going to be evicted, even if you paid your full rent, because you still owe the arrearage, correct?
That's correct. And if you're having problems at the house, I can bet that those problems have not been fixed, and it seems like it's a one-way street. They want their money, but they're not going to keep that property up to code or safe.
So the best advice you can give someone when they're renting, if they have a lease, is what should they do?
Well, they should certainly read the entire contract and understand what they're signing up for. And I don't think it would hurt if you asked that certain provisions maybe be maybe less money, because it is a contract, and some of these places could negotiate. If you don't want to pay $10 by paying by mail, see if they'll take $5 if you can afford that. But the biggest thing again is keeping track of these conversations you have with the rental company, keeping track of of any problems that you're having, and just basically maintaining a record so that if it comes down to you have to withhold your rent because work's not being done, you have a record of that, and you go before the judge, and the judge will understand that you've been fighting to have the company make these repairs, and they're not doing it, and the judge could look favorably upon you.
Now, you raised a very interesting point. I'm living in a unit, whether it's an apartment or a house, and I'm a renter, and there are problems with the property, and the landlord hasn't fixed them. I want to withhold my rent, but I don't want to get evicted. So what am I supposed to do with my rent?
Well, one thing you can do is you can go to your bank and you can open up an account, which is basically an escrow account. You can pay your rent that you would normally be paying to your landlord. You can pay that into the bank, and the money's there. And then when you go before the judge, which you will do because they will file a notice of eviction, then what you do is you can bring the account ledger to the court and say, Judge, I've been paying the rent into the escrow. They haven't made the repairs, and you'll be in much better standing than just withholding your rent and not having it when the time comes to go before the judge.
One of the things that I recommend to people when they ask me these questions is, if you're going to pay money into escrow, let the landlord or the management company know that there's an escrow account and the money's sitting in the escrow account. And when they make the repairs, you'll tender the money.
Certainly.
Saves a lot of trouble. We're going to take a break for a minute. We'll be right back.
Are you in legal trouble? Are you in need of legal advice? Or just have general legal questions? Call 1-800-529-8721. That's 1-800-LAW-USA1. And watch Law Power Hour and get your questions answered by experienced attorneys who are experts in their field. That's Law Power Hour, hosted by Barry Keller, attorney at law. Saturdays at 10 a.m. here on WHPR Detroit Live.
Today our guest is Attorney David Kramer. His office is in Royal Oak, Michigan. He practices all over the state, does personal injury, all forms of it. David, thank you for coming.
Thanks for having me, Barry.
We've got a problem in Michigan. They're trying to pass legislation which was defeated in 2017. They're working at it again to change the automobile no-fault package. Is that correct?
That's correct.
Come on a little closer, because this is really, listen, if you're out there, it's really important to you. There's a lot of you who are uninsured, and if you're uninsured, you can't make a claim in Michigan.
That's correct.
So if you're driving a car and you're uninsured, you're out of luck.
You are out of luck.
This past week, I had 3 people come in. They told me their insurance was expired. I asked them when it was expired. Unfortunately, most of them had insurance expired several months ago. But for some reason, after this horrific storm we had, bad weather, it seems we're on the thaw side of it for a moment. We're having more accidents in the last week when we're on the thaw than when we have icy streets. And it's a big problem, isn't it?
It's a huge problem, and operating without insurance is the last thing you want to do in this type of condition.
So Mayor Duggan and his regime has been pushing for legislation to make sure that everybody's insured, correct?
Correct.
Now, there's nothing wrong with having de-insurance, is there?
No, there's nothing wrong with that at all.
And the principle behind what the mayor has proposed is that everybody should be insured is a good principle, isn't it?
That's a great principle.
Because there's redlining. In other words, depending on where you live, you're paying, horrible rates for insurance. And would you agree with me, one of the problems is that you got to have insurance where you live and stay. And I'm saying that because it's real important. Because there's a lot of people who live one place and stay another place for the purposes of insurance, and that's illegal.
That is fraud, correct?
So in other words, if you live in Detroit and you claim you stay in Farmington Hills because the insurance is 35% less in Farmington Hills, you lose your insurance, don't you?
Right. If you make a claim, you will lose your insurance.
Okay, so now getting to the bottom line, although we support the mayor's idea and principle, his package has a lot of holes in it, doesn't it?
Is packaged, yes.
Okay, and catastrophic injury claims, is that one of the big areas?
That's one of the big areas, and that the catastrophic injuries are the horrible ones, the ones where people may end up in a wheelchair for the rest of their lives. And under the mayor's plan, there was a proposed cap on the coverage for that.
His cap was like $350,000 or something like that. I can't remember the exact number.
Right. Under the current plan, there is no cap, and those benefits are provided for the lifetime of the injured person.
Now, or at least the legislature is going to come back, and he's very supportive of a new bill on no fault, correct?
There's anticipation of they're working on a new. There will be a new attack on the no fault scheme.
Let me ask you a question as a brother attorney practicing in this area. Do you believe, and I'm putting you on the spot with this one, do you believe that TV advertisers are responsible for part of the reason that they're trying to put a cap on insurance?
I don't think that they're in part responsible, but I think that's easy for the enemies of no fault, the insurance companies, to point at and say, look at what's happening here, that's why your rates are so high. And I don't think there's a factual basis for that.
And do you think that there's a proliferation of claims out there because of no fault today? In other words, there's just too many claims are being filed indiscriminately that shouldn't be filed.
There's certainly claims that when you review them, maybe they don't have a basis or a strong basis, but additionally, what they have is denial of claims from insurance companies. And so there's blanket denials on the side of the insurance companies, and there's just constant flood of claims. So how does it wear out, even out? I mean, it's tough to explain or show, but at the end of the day, you've got high denials by insurance companies, and you have a proliferation of claims, and it's easier for the people with the most money, meaning the insurance lobby, to point and say, look at all this, this fraud and this waste.
Now, today, we've got a government shutdown in Washington, so State Farm Insurance has more money today than the CIA to investigate people. Does that make sense?
That doesn't make sense, and that's generally not the intended role of a car insurance company.
But they can call you in if you're involved in an accident. They can call you in and they can stigmatize you under a contract if they investigate you and you've had a prior injury, correct?
Correct. They can do what's called an examination under oath, where they'll swear you and hold you to basically perjury standards, and ask you any question under the sun, and what they're doing is, quote, conducting an investigation. And it can be very traumatizing and very intimidating.
Gives them a couple bites at the apple.
Correct. They can come back later after you, if you have to file a lawsuit, and use that testimony against you.
So here's my point. If you're involved in an accident, you're legitimately injured, once again, I'm going to ask you for the Kramer formula. What should people do when they're involved in an accident? I want the Kramer formula, not the Keller formula today, but I want to hear from you, a trial lawyer. What should we do?
Certainly, the biggest thing is seek your medical treatment. Either if you're involved in a car accident and you want medical attention, you can have an ambulance take you to the hospital or to a facility to check you out. And then you want to document that. You want to make sure that when you follow up, and that's the other key, is following up with your medical providers, is let them know that you're there because of this accident. You don't want to explain that, this is a, you just want to make sure that they know why they're treating you, and this is a new injury, not something that has been ongoing, and it's not just some pain. But the biggest thing too is another point to that is you want to be truthful. You don't want to exaggerate what's happening, because at the end of the day, you may be judged by a jury, and who will be able to weigh your testimony. And if it seems like you're stretching the truth, you could be punished for that.
So if I'm involved in an accident and I call you on the phone, say I've been to the emergency room, I've got an accident report, I was insured, the driver of the other vehicle we believe was insured, and I want to see you, but I don't have a doctor, what are you going to tell me to do?
I'm going to tell you to go see a doctor. Find if you can go to urgent care, that's a place where you can get treatment. But you really need to follow up, because in the eyes of the insurance company, if you go to the ER and that's it, and nothing more, then that injury hasn't affected your life.
Okay, let's talk about that. What is the test in Michigan today to make a claim against the driver of a vehicle if you're injured for personal injuries?
So you have to have what's called a serious impairment, and the serious impairment is the full phrase is serious impairment of an important body function. And so when the court analyzes what a serious body function is, walking, standing, sitting, all those things that you do every day that you don't think of, those are all serious, because if you can't do those, that's going to have an effect on your life. And so the other is it needs to be an objective, objective impairment. I always twist those ones up. If you could give me that second prong.
You mean that objective manifestation?
Yes, thank you, the manifestation.
Okay, well, it's the same thing. It's an impairment, but talk about a manifestation. So one of the things that's really important is weigh your life the day before the accident. Put it down on a piece of paper. Take a piece of paper and fold it in half and say, what could I do the day before the accident that I can't do now?
Or write down the things that you no longer can do. I want to go to the park with my kids, but I can't because of the pain in my back or the pain in my legs. The things that this accident is stopping you from doing, that's important. And those are the sleeping at night. Those are the type of things that we take for granted, but when they're taken away from us, we really know what the accident has done to us.
And in terms of documentation, is that the most important part, again, like we talked about in the first half an hour?
It is. It is. Without proper medical records, you can keep a pain journal to record, how you're feeling. If you have a family member or a friend who's helping you around the house, you want to make notes of all that, because those documents, if you keep them at the same time that they're happening, those will help you establish your claim, and those will just help you in the long run.
Okay, other than, I have to switch gears for a moment here, other than the objection to the cap on catastrophic injuries, what other objections do you believe existed under the old law that was just proposed?
Well, certainly the cap was very problematic. There was also, I think, there was a fee schedule, meaning that doctors and providers could only charge a certain amount, and that made a lot of people unhappy. There was also the prospect of people who would run out of insurance from the cap. They would then be forced onto Medicaid, and that would then shift the burden of paying these insurance claims to the taxpayers, take it away from the insurance companies. And that is a huge benefit for the insurance companies, but unfortunately, it's essentially taxing the people who are paying for insurance.
It also burdens injured individuals because if they have a recovery for their injury and they have any money in the bank, they can lose their Medicaid eligibility if they're forced onto it.
Correct. Yeah, that's a side of it that people don't realize until they're in that position, and at that point, it may be too late. Also, there was an issue with the drivers, the at-fault driver. You couldn't sue them for the remainder of any unpaid medical bills or continuing medical bills.
Okay. When I was reviewing your CV, I saw that you did some products liability work. You still doing that kind of work?
Yes, a little bit.
It's automobile or other types of products?
Automobiles, general products. I have lawn equipment, chairs, things of that nature. Everyday products which are increasingly more and more manufactured overseas, and it gets tricky because, again, like the foreign investors in local real estate, you have foreign companies who are very hard to track down. But in certain instances, you can get a company, a local company, or a company, domestic company, liable for altering a product or not warning you about a product.
Okay, let's talk about some of those cases that I think it's important for our listeners. You're riding in the car. There's an issue about the airbag. What should they do?
Well, they should, again, document it. If they're in a collision and the airbag does not go off in say, a front-end collision, you definitely want to document that. But the one crucial thing is the vehicle that is involved in the accident must be maintained in the post-accident condition. You can't have it repaired, and you have to hold on to it. A lot of times what happens is these vehicles are towed from the scene. The insurance company will pay you for the value if it's totaled, and they'll take it to a yard where it will be destroyed. Once that car is destroyed, so is any chance of a recovery against any of the manufacturers.
I don't think most of our listeners know that there are certain sensors that keep records inside vehicles.
Certainly, with the advancements in technology, cars are like mobile computers. So there are accident, databases, readouts that you can obtain. You can hire somebody to download that information, and you have basically the information. It's out of what's called the black box. And
I want you to talk about
sure.
that.
So the black box has, you can download the data, and you'll see the speed of the vehicle at the time of the collision, if the brakes were applied, what was happening, and then the slowdown of the impact. Plus, you also have the if the airbags were set to fire, why they didn't fire. All that information is in there, and to get that is key to a successful lawsuit.
Right. In other words, if there's a dispute as to how the accident happened, let's say that there are two cars going in the same direction, and you claim that another car came into your lane of travel, you'd want to get the black box to prove that you were in your lane, wouldn't you?
Certainly, you'd want to, and the same goes for speed. That would help assist you with evidence of what was happening at the time of this collision.
And that would make the difference between success and failure.
Certainly.
I had a real interesting experience that I want to share with you and our audience. I had a client who was involved in an intersectional accident. And the insurance company said, we're not going to pay the claim. Your client ran the red light. So my client went out to the scene of the accident, and there were 4 gas stations. And he went to all 4 gas stations to see if they had videos. And one of them had a video of the traffic out in front of the station, and it showed the exact accident, and it showed the car that I sued. It showed that vehicle running the red light. So you've got to go out and exhaust all your resources. So if you're involved in an accident and there's a dispute as to whether you ran the red light or somebody else ran the red light, don't wait 6 months to go out to the scene of the accident. Go out, or have somebody in your family go out and find out if the gas stations have videos, because that's going to make the difference between a win and a loss.
Certainly, and it goes without saying, but I'll say it, is to contact an attorney who knows to do that. Most people won't know how to do that. So what happens is that information is rewritten and it's lost forever, and there goes your best chance and your best evidence of proving your case.
I had a client go to a U-Haul to make a payment for a friend, and he slipped and fell getting out of his vehicle. The U-Haul had cameras, security cameras all over the place. So we have now documentation as to how the accident happened. So that's how important it is to have this information.
Yep, and to know, to hire somebody or contact somebody who knows how to get it.
Okay. Now, in terms of products liability, you raise some really interesting issues. I go to one of my local large stores. I can't mention stores by name on the air, but they sell all kinds of products, you know. And I go there and got a sale on lawn chairs. Take the lawn chair home, I sit down on it. Bingo, I'm on the patio on my back as the chair broke. Find out that it wasn't put together correctly. Do I have a lawsuit against the Megabox Corporation that sells them?
If they in fact put the chair together for you, yes, you do.
Okay. Suppose I get it delivered in the box by one of these delivery services like FedEx, Amazon, whatever, you know, one of them delivers it to my house.
No, you don't. Not against the delivery company.
Well, what about the manufacturer?
The manufacturer, yes, you could, but again, it's a tricky proposition, but one worth exploring.
Okay. What should people do if they have this happen?
Well, if they have it happen again, hold on to the product. Do not return it to the manufacturer. Photograph whatever you claim if you can see something that's broken, but maintain any writings, any documents that come with the product. And what you really need to do is contact a lawyer who does have experience in investigating these cases. And again, follow up with your doctor, because if you do have a product that fails and you didn't get hurt, but boy, you could have gotten hurt, you really don't have the basis for a lawsuit because you don't have any damages.
Okay. You mentioned chairs. Have you handled any lawn chair cases or chair cases?
I have.
Okay, let's talk about them. I want our listeners to understand a little bit more about the depth of your practice.
All right. So one particularly grisly case I had was I had a client who purchased a chair from a local big box company, and it was a sliding, rocking recliner chair. And in the normal course of him sitting down, he would reach back towards the back of the chair, and the chair would slide back, but there was a gap where your hand would go naturally, but that gap also acted as sort of a guillotine, and as he slid back, he had his pinky finger in that slit, and it chopped the top of his finger off.
And who did you sue?
Well, we sued the big box retailer, and it was a Taiwanese company that manufactured the chair.
Did you recover?
Well, yes, but on a very unique theory. The big box retailer had a company that tested these products, and so they hired a company to basically review the things before they went out on the floor for sale. And so through that mechanism, we were able to say that the big box retailer knew, or they had it tested, so they should have known that this was a possibility.
Okay, so that's why people have to go to a lawyer if they have a defect.
Yes, because in a case like that, no customer would know that there's a potential for a third party or a testing company that should have some knowledge of the possibility of this injury.
What other types of products have you had?
I have another chair, which is a theater seat. A lot of these movie theaters have these modern reclining, almost like a a sofa bed to lie down on while you watch your movie. And it turns out that underneath these reclined seats, there is lots of sharp edges. And if someone were to put their hand down there, or if a child, may climb under there, there's tons of hazards, and there's nothing to protect, limbs or any parts of the body from these sharp edges.
Do you sue the installer? Do you sue the manufacturer? Do you sue the theater? Who do you sue?
So the theater, and then the manufacturer of the seat. So all those come into the lawsuit, and a lot of times they'll blame each other, and that one's still to be determined how it's going to play out.
And did you sue everyone?
Yes.
Okay, what was the injury? I'm just curious.
It was a facial laceration or cut to the face for a 7-year-old child.
Who had crawled under the seat?
Yeah, to retrieve a teddy bear that had fallen.
And that's not unusual. It's foreseeable. A child's going to do that in a show, isn't it?
Certainly.
Okay, so here's a man who's willing to stick his neck out to represent you. Tell us how to reach you.
Okay. Like I said, we said at the top of the hour, my office is in Royal Oak, Michigan, right on Woodward Avenue, right across from the zoo. My number, you can reach me at 248-210-6757. That's my office phone. That's my cell phone. You can talk to me directly, and if you want to come in, discuss your case, I'm happy to set up a time. And if you're unable to travel, I can also travel to you, so I'm able to do that.
So he's here. His cell phone's in his pocket. So you've got a question, call him up. Before you leave, I've got a real important topic to talk to you about. There's an opiate epidemic out here. And I didn't want to say it was academic. It's an epidemic. And there's a lot of litigation going on over this today, isn't there?
There is.
And don't you think our listeners should be aware of what they can do if they're hooked on opiates because some doctor put them on the opiate?
Certainly. There is certainly an epidemic, and this has been ongoing for years now, but it's reaching to a point now where we're seeing it everywhere. One of the things, there are treatment centers. I'm not really certain on the areas of treatment where they are, but if people are at a point where they're taking these things daily and they're not seeing improvements, that's something that they need to speak to maybe another doctor other than the doctor who's prescribing these. That's a lot of times it's easier for the doctors to continue along this treatment, but if you feel like it's interfering with your life and not making you better, then treatment is something you should certainly seek
Well, the
out.
other issue is that our association has lawyers who are handling class action suits against the drug companies for addiction. So we need you to contact lawyers to find out if your loved ones have a right to make a claim because they're addicted to opiates as a result of doctors who have overtreated them and prescribed pain medicine for them that they don't really need.
That's correct. It hasn't been filed, but what it is you get contact a lawyer, become a member of the class, and if you're entitled to compensation, anything like that, that's the first step, and one of the first steps in getting this problem done, because it's not coming from Washington or Lansing.
No, but there are a number of states that are hiring lawyers to sue on behalf of the states the same way they did with tobacco litigation because of the addiction problem.
Correct.
And I just want people to be aware of this because it's not a problem that's going to go away. It's a problem that exists. Good morning.
Morning. Attorney Keller, you posed a great question there in regards to the class action lawsuit against doctors and insurance companies with the opioid addiction. But wouldn't that raise the insurance rates for those doctors that then, with that class action lawsuit, wouldn't that raise the insurance rates for the doctors, and then the doctors would then put that burden upon the clients that are coming in and charging their insurance firms even higher, so the cost will then be mitigated back to the patient?
Sue the insurance company, not the insurance company, sue the drug manufacturer. They're the ones that are entertaining the doctors and giving them all kinds of perks for prescribing the medicine. Would you agree with me?
That's correct.
Yeah, the target isn't the doctor as much as the government will get after the doctors. The DEA will get after the doctors if they're overwriting, prescribing medicine. But the real culprit is the drug company.
That's correct. And it's the drug companies that will continually, dump these, drugs on the market, entertain these doctors to keep prescribing them. But the comparison to the tobacco companies, it's the same idea. They're the root cause of this problem, and they're the ones who should pay.
I mean, the drug companies have made billions of dollars at the expense of citizens who were injured and who need medication and who've been hoodwinked into taking this medicine, correct?
That's correct.
And now we've got to deal with the fallout and try and get these individuals rehabilitated, which is virtually impossible. Because now they got to go to the streets to get their medicine,
That's correct.
and that creates other problems.
Yep, and it's costly, and it's going to cost cities and states across the nation billions of dollars. And at the end of the day, the drug companies are the ones who are making the money off it.
And even the guy in Washington with the orange hair is opposed to the opiate issue.
Yeah, so he says.
Well, but the point is that I think everybody's on board when it comes to this issue that we've got to do something about it. David Kramer, thanks for coming. It's
Great.
been fun having you. And give our listeners your number again, because some of you will have to watch the show later in the day because it's repeated.
All right, I can be reached at 248-210-6757. And any types of problems, I'm happy to. If I can't help you, I know a lot of qualified attorneys who certainly can, and I'm more than able to forward your information on to try to get you the help you need.
David's a sole practitioner. He takes his work seriously, and he does a good job. Thanks for coming.
Thanks for having me, Barry.
See you next week.